Thank you very much. It's a pleasure to be joining you all, although, of course, not at all a pleasure in terms of the terrible nature of the subject matter of this event. I've been asked to speak about a legal opinion that I was asked to prepare for the Arab Organization for Human Rights in the UK concerning the legal consequences for third states, so states other than Israel and the state of Palestine, for legal consequences arising out of the illegality of Israel's current operation in the Palestinian Gaza Strip. And today I've been asked to summarize that legal opinion. So this is a legal opinion that will be then sent to these states to remind them of their legal rights and their legal obligations. I've written this legal opinion and I'm speaking today only in my personal, private, individual capacity, not in my capacity in any other sense, and only on behalf of myself and not on behalf of any other entity. In order to determine the legal consequences for all other states, we need to clarify the illegality of that which Israel is conducting. And it's important to appreciate that Israel's current use of force in the Gaza Strip is but part of a much more long-standing illegal use of force by that state in the territory, which began in 1967. So that use of force, which continues today, is illegal. It is a violation of the international law on the use of force. It's an aggression and also a violation of the right of self-determination of the Palestinian people. In addition, of course, tragically, the use of force in its current manifestation, which is a supplementing the prior forced enabled siege with what has been aerial bombardment and a land invasion, also involves breaches of the laws of war, that's to say international humanitarian law, including serious violations which constitute war crimes and breaches of the prohibition of apartheid in particular and racial discrimination more generally. Some of these breaches are, of course, a continuation in more extreme form of what happened prior to the current bombing and land incursion campaign. And also now a credible case is being made by certain states, United Nations experts, and human rights NGOs that crimes against humanity and genocide are being committed. Now, Israel is obliged to cease its illegal behavior immediately. That's a consequence of it being illegal. That therefore necessarily means a ceasefire and a withdrawal from and complete termination of the force-enabled siege of the Strip. Because fundamental international legal rules are being breached by Israel, this has particular consequences for all other states, consequences that would not arise were these rules not to be so fundamental. And in international law, there's a fundamental category of legal rule, the rules that concern the prohibition of aggression, the right of self-determination, the prohibition of apartheid in particular, and racial discrimination more generally, the prohibition of core rules of international humanitarian law, which if breached constitute war crimes, the prohibition of crimes against humanity, and the prohibition of genocide, which have a special fundamental status. And that fundamental status means that all other states are legally implicated in their violation. put simply, they are not in a legal position where they can simply choose freely to decide how to react, and indeed whether even to react at all. They have a right and also, in certain circumstances, an obligation to take action. The consequences will be set out in full in this legal opinion, but just to summarize them briefly here, what this means is that all other states are legally obliged not to recognize as lawful or provide any aid or assistance to Israel's use of force including its occupation of the Gaza Strip. So this means necessarily not affirming that Israel has a right to use this force, and also ceasing support, including military support, to Israel for this purpose. They must also take positive steps to bring the illegal situation to an end, including calling for Israel to take the actions it needs to take to bring the situation within the boundaries of compliance with international law. Now, I'm conscious of the time, and there are many examples that could be given and are given in the legal opinion of the various steps that states must take to change their behavior, and also areas where they could deliver on their legal obligations. I'll just perhaps give an indication where it comes to international cases. Because of the fundamental nature of the rules being breached, all other states have a legal obligation, so a positive duty, to take action to bring these violations to an end. And one clear way that they can discharge this obligation is to seek to bring or support international cases that would involve the adjudication of this situation and a determination as to its legality or illegality. And there are two main arenas here. The two courts in The Hague, sometimes confused with each other. There is the International Court of Justice in The Hague, which can hear disputes between states and also which renders advisory opinions to the United Nations. And in those interstate disputes, states are able to bring cases against other states for violations of these fundamental rules, even if they, the claimant state, are not directly affected by those violations. And obviously, one core area of international law that's significant here is the prohibition of genocide under the Genocide Convention. Under the Genocide Convention, which Israel is a party to, any other state is able to bring a case to the International Court of Justice against Israel concerned with violations of that convention. It does not have to be the state of Palestine. And one or more states bringing such a case would do so pursuant to the obligation that they have to take measures to bring the situation to an end. The other thing that I will cover finally is the other court in The Hague, which is the International Criminal Court. That court, it isn't concerned with the responsibility of states, as in the International Court of Justice, but rather the individual criminal responsibility of individuals for the same acts that give rise to state responsibility. Now, that court is already concerned with the situation in Palestine, in that the state of Palestine has ratified the Rome Statute, and it has referred the situation in Palestine to the court. That has been the situation for some time. However, as we know, that court and the prosecutor in particular is placed under exceptional pressure by those such as the USA who are opposed to the court addressing it. That is considerable exceptional pressure, and pressure that is being placed on the court in the context of the court's exceptionally precarious position, precarious existential position. And the only way to counter that is for other states to offer countervailing support to the prosecutor and the court for their actions in taking an investigation and a prosecution forward in relation to the situation in Palestine generally and the current situation in Gaza in particular. And third states other than Israel and the state of Palestine, can do this in two concrete ways. Firstly, they can join the 5 states that have already joined that referral of the situation in Palestine to the court that was made by the state of Palestine itself. And we have to contrast 5 states having done that with the 43 states, parties to the Rome Statute, who referred the situation in Ukraine to the court. I was seeking to clarify that, of course, that there are 2 courts in The Hague. The International Court of Justice, which hears disputes between states, and there a case could be brought against Israel. It would not require Israel's consent under the Genocide Convention, and any state could bring that case. And indeed, a group of states could do so as an act of joint solidarity. The International Criminal Court, which prosecutes individuals, not states, wouldn't prosecute Israel, the state, prosecutes individual Israelis involved in the crimes that fall within the jurisdiction of the court. The court has accepted that the state of Palestine's ratification of the Rome Statute is valid, and that means that the court does have jurisdiction with respect to violations of the crimes under its jurisdiction in the territory of the state of Palestine, regardless of the nationality of the offender, therefore potentially encompassing such violations by Israeli nationals and Palestinians alike. It's not about their nationality, it's about where the crimes, alleged crimes, were perpetrated. And again, Israel's consent to that is not required jurisdictionally. The issue is the political and partly financial and practical realities that one of our, Bruce, if you don't mind me addressing you in that way, reminded of us of in the previous statement. And indeed, they are considerable. And all I would say there is that they are not a given, in the sense that they can be challenged, and countervailing support can be forthcoming to the prosecutor and the court, which isn't at the moment being provided by those states who, on the other hand, express concern about violations of international law being committed at the moment. So they, as I mentioned, because they're under a legal obligation to take steps to bring these violations to an end, there's a concrete way that they could deliver on that. I mentioned the possibility of making referrals, that's to say joining the existing referral, adding their weight to it, but also financial support. Whether or not they're parties to the Rome Statute, states are able to pledge financial support to that court specifically to support the Palestine investigation. And again, it's notable that this support has been given by third states for the Ukraine investigation. And I must stress, because of the important and ongoing concerns about the ability and the willingness of the Office of the Prosecutor and the court to address this situation, other states need to counter this through political and financial support if there is any hope that the prosecutor and the court are able to withstand that pressure and deliver justice to the Palestinian people, which is, of course, a good in and of itself, but also potentially a vital means of enabling greater compliance with international law by Israel, an objective which, as I've mentioned, other states bear a legal obligation to secure.